Thank you very much, Madam President. Colleagues, good morning. I have prepared some brief slides to aid the presentation. So if you permit me for a few minutes, I will share my screen with the slides and then we can get rolling. So give me a few minutes. All right, good morning again. So we know today's topic for our CLE, it's COVID-19 and enforcement of contracts. I have very brief objectives for what I'm about to do. That is that by the time I'm done, I hope that we all are able to refresh our memories on what frustrating events are, and particularly whether COVID-19 is a frustrating event. Then flowing quite naturally from that will be if COVID-19 or any follow-up actions will be a frustrating event or frustrating events, what are the consequences? Now, as we all know, when you put together a contract, there must be a time that that contract has to come to an end. So I typically say here, whatever has a beginning has an end applies here. And one of the circumstances in which a contract can be brought to an end is frustration. But we know generally that a contract may be determined by performance, and when performance happens, all of us are happy, because the whole essence of entering into a contract is that it be performed. So when it is performed, we are all happy. It can also happen by agreement of the parties. It can happen by breach, and it can happen by frustration. I recategorize these four modes of discharging a contract into three. I look at performance and agreement as lawful modes in a very liberal sense, breach as an unlawful mode in a very liberal sense, and frustration as neither lawful nor unlawful. So let's focus on frustration. That's the reason we're here. When can we say that a contract is frustrated? Here, we're talking about change in circumstances after the contract was made, which change is not a result of fault on the part of any of the parties, and that must result in one of three I's. So I said you need one of the three I's below to say that a contract is frustrated. The first one is that the event which you're calling a frustrating event must render the performance of the contract impossible. This I call factual impossibility. That is my first I. The event must also deprive the contract of its commercial purpose. So impracticability business-wise, that's what I call the second I. Then the parties themselves, in negotiating the contract, may have identified certain impediments. And when those impediments, one or more of them mature, then you have the third I. It is this third I which connects with what is popularly referred to as force majeure clauses. And we will get back to force majeure clauses very soon as compared to frustration. So when a contract is frustrated through and through, it discharges the parties from future obligations, emphasis on future. It discharges them from future obligation. If this were not so, it would have altered the fundamental obligations that the parties had undertaken under the contract. Davis Contractors versus Fairham provide us with an authority for that. Again, regarding frustration, the law is that it is a matter of law, not a matter of fact. It's a matter of law whether or not there is frustration. Barclays Bank versus Sakari, I'm sure many of us are familiar with this case, provides us the authority for that. I will get back to the facts of Barclays Bank versus Sakari very briefly. Then again, at this point, it's important to point out that not every hardship which occurs after a contract has been executed or formed that will amount to frustration. Davis Contractors, again, is authority for that. Because not every hardship will amount to frustration, what we really need to look out for is the fundamental obligations undertaken by the parties. Is the frustrating event preventing you from discharging on your fundamental obligation undertaken under the contract? Here, Barclays Bank versus Sakari is very instructive, very interesting case. A case in which Mr. Sakari took some loan from the Barclays Bank was to purchase a certain type of vehicle to do his business. He bought a different kind, but that was not really a big problem. But then in the process of using the vehicle to work so he could pay the loan, the vehicle was seized. And so he defaulted. Afterwards, Barclays Bank then brought an action against him to recover. And he says, hold it. The reason for which I got the loan was to procure a vehicle. The vehicle had been seized by government, and so the contract is frustrated. After the court, having examined these in detail, came to the conclusion that, well, the fundamental obligation here is not for you to buy a car. It's for you to take a loan and repay the loan. That's your obligation, and repay the loan. So here, frustration did not come to the aid of Sakari. The courts have also discussed the relationship between force majeure and frustration, and noted that frustration is normally talked about when you talk in international business environments. You can look at the case of Affording versus the Ghana Publishing Corporation. I know there's so much interest in trying to find out the distinction, if any at all, between force majeure and frustration. So let's spend a bit of time on this. Force majeure is a French term simply meaning superior force. And when you put together a force majeure clause, typically it will cover instances of war, strike, riot, acts of God, which may include bad weather, rainstorm, and perhaps illnesses. So our eyes and minds on COVID-19. Why are force majeure clauses required or recommended to be included in contracts? The fundamental idea is that, well, we work in a world of uncertainties. And so the expectation is that any party entering into a contract will try as much as possible to foresee the future uncertainties and plan for them. So it is advised that when you plan for them and they occur, then the clause can help you to deal with some of the losses which may be occasioned because the uncertainty which you had foreseen matures. A force majeure clause is therefore a mechanism which allows the parties one or both of them to complete the performance of the contract or even cancel it. It gives you the freedom to decide how you want this hardship, if it occurs, to be treated. A force frustration will bring a contract to an end, but as compared to a force majeure clause, there is so much control and flexibility in the hands of the parties to the contract, so they can decide what they want their force majeure clause to be. Frustration is not like that. When it comes, it brings its effect of ending the future obligations of the parties. So the parties are at liberty to make express provision regarding some supervening event which may frustrate the contract within the context of force majeure clauses. So the law will not prevent the party from relying on a force majeure clause, even regarding events which are occurring at the time the parties are or were executing the contract. Frustration is not like that. Frustration is about an intervening event which is occurring after the contract was concluded. Now, there are other clauses that you will typically find in contracts which are to help mitigate hardships which are brought onto the parties. So you'll find some called hardship clauses or intervener clauses. Force majeure clauses, when they are in a contract, the default position is that you will resort to them when the hardship that you have foreseen, and provided for occurs. However, it is not the case that force majeure clauses always override frustration when you're looking at it from a common law perspective. The Metropolitan versus Dick provides us an authority for that. I have just reduced what I've explained into a little diagram, table rather, looking at a number of factors. So the time of occurrence when it is force majeure versus when it is frustration versus, and also when can either of them apply regarding force majeure. Even when you contemplate the hardship, still it can apply. But regarding frustration, you will not have contemplated this hardship occurring. Does any of them take precedence over the other? I explained that a bit more. So this is just a diagrammatic representation of what I just explained. Now, I know that the key reason we are talking is how COVID-19 may be treated as a frustrating event or not. So there are some typical general examples of frustrating events. And I want to list them to see if we can compare them to the occurrences of COVID-19 and the follow-up actions to see if any of them will give us comfort to say that our contracts are frustrated. Personal incapacity will generally render a contract frustrated. Conda versus Baron 9. This is part of the cases that you call the coronation cases. So if you hire a place for a particular purpose and the person who is supposed to be the subject of that event is taken by illness, so he is personally incapacitated, that contract will be deemed to be frustrated. Where the contract becomes illegal to perform, RT Briscoe versus Asian, where Mr. Asian had undertaken to supply some timber, and after the contract was executed, he couldn't do so because there was a law which says that only the Timber Marketing Board could trade in such types of timber, and he says that his contract was frustrated. So here you're talking about the law intervening. So the Imposition of Restrictions Act is on our minds at this point, to see if this act will render certain things that we had undertaken to perform under contracts illegal if we perform them now. We know about the closure of the borders, international borders, and so again, that has a direct implication for contracts which have been entered into. A contract may also be frustrated where it is deprived of its commercial purpose. And if you have more than one commercial purpose, all the commercial purposes must be deprived in order to say that the contract is frustrated. If you have more than one, only one is rendered frustrated. If only one has been deprived, then you can't say that the contract is frustrated. You need all of them to have been deprived in order to say that the contract is frustrated. Again, a few more things connected to the example that I've cited. We know that mere difficulty or extra expense will not frustrate a contract. Davis Contractors versus Fairham again comes in handy, where you have more expenditure incurred as a result of an event occurring. That will not necessarily lead to frustration. Where you are supposed to deliver courses to students face to face, and you can't do that, but you have the online platform encouraged by Madam President for us to use coming to your aid, the extra expenditure or the difficulty may prevent you from asserting frustration as a defense. Now, even if there is an impossibility of performance, which is one of the first things we require, that impossibility will not frustrate the contract if it arose as a result of fault on the part of any of the parties. Maritime National Fish Company versus Ocean Trawlers, where the plaintiffs who had hired out some trawlers and the trawlers required licenses to operate, they were granted 3 licenses when they had 5. They chose to assign those 3 licenses to their own. They could not sustain an action against the defendant because they themselves brought about that event that you can call a frustrated event, even though it was an impossibility to start with. Again, as I explained a bit earlier, where there is a force majeure clause, this will apply. But the force majeure clause will not necessarily override principles of frustration. An interesting insurance and howsoever cause will not should not frustrate the contract, but should lead the defendant to ask for more time. The court construed this as not covering all delays. Okay, so this is the force majeure clause, but here principles of common law principles of frustration came to the aid of a party here. There will be no frustration where the frustrating event should have been foreseen. Here, you're really talking about, you could be thinking in the case of COVID-19, so the COVID-19 pandemic has started, you have entered into a contract with some future obligations, you could, on a balance of probabilities, foresee certain things happening. So if you didn't provide for them, you can't come back here to say that the contract is frustrated. Now, when we want to use frustration as a defense, the first thing is that we're going to be, laying our case before a court, and the court has to decide whether or not really there is frustration. And the duty of the court, as I said a bit earlier, and as supported by Barclays Bank versus Sakari, is for the court to really identify the fundamental obligations of the parties and compare the fundamental obligations to this supervening event which is occurring to see if it is really preventing the party from performing the obligations that they are taken under the contract. Frustration is not meant to be an easy way out of a bad bargain. Not at all. If you went into a bad bargain, frustration is not the defense to which will come to your aid. As I said before, it is not a very difficult make reasonable efforts to look for alternatives possible for us to perform our obligations, then frustration may come to our aid. What are the consequences of frustration when it occurs? And I'm actually almost ending my presentation. We can find these consequences both in common law but also importantly under our Contract Act. Interestingly, the very few, the first part of the Contract Act deals with frustration of contracts. Section 1, in essence, say that when the contract is frustrated, future obligations cease to exist, but accrued obligations continue to exist. All monies which are payable cease to be payable. All monies which are paid can be recovered. And expenses which are incurred before the frustrating event occurs are recoverable, subject to fairness and the justice of the matter. But again, you cannot recover expense when there's frustration, expenses beyond what you expended or the total cost, the contract sum of this particular contract. Section 2 in some summary just says that you can't take sever the frustrating part of the contract from the portion which is not frustrated, and therefore go ahead and enforce the part which is not frustrated. Interestingly, Section 3 deals with the parties opting out of the provisions of the Contract Act regarding frustration. So where you don't want the Contract Act to apply to you, you are at liberty to opt out of it. But of course, that's something which would have been done at the time of negotiating the contract. Now that we're talking about, contracts being frustrated, we will look at, the provision to see if the parties really didn't want the Contract Act to apply to them. So in conclusion, is COVID-19 a frustrating event? As I have explained, you need either a factual impossibility or an impracticability business-wide, or an unsurmountable impediment identified by the parties themselves within the context of a force majeure clause to say that a contract is frustrated. At this point, COVID-19 outbreak per se may, depending on the facts of a particular case, be a frustrating event. Here, for instance, if somebody is infected with the virus and so cannot discharge on his obligation directly, then we can see directly that COVID-19 is frustrating that contract. Other contracts, it may be events which particular governments have imposed following up on the outbreak. Here, look out for the fundamental obligations of the contract, particularly captured in the conditions of the contract. Consequences when frustration occurs. As I said, monies paid are recoverable, monies payable cease to be payable, expenses incurred are recoverable, but subject to fairness and the justice of the matter. I thank you so much for giving me the opportunity and listening to me. Akbenani.